Welcome everyone to today's session of Entrepreneurs Toolkit. I am Victoria Kahipe, Associate Director with UC San Diego's Office of Innovation and Commercialization, or OIC. OIC is the host of this series of talks, which explores various aspects of technology commercialization, company formation, and funding. Today's webinar is on artificial intelligence, or AI. AI has been around for decades now. Back when I was a student, it was a fairly esoteric topic. But today, AI seems to be everywhere, from a detection of COVID based on chest X-ray images to smartphone apps that approach deepfake video capabilities. Here to speak to us today about AI is Pedro Suarez from the law firm Mintz. Mintz is also a sponsor of this event, and we are thankful to them for that. OIC has been working with Mintz for many years now as patent counsel for UCSD inventions and collaborator in outreach events such as today's. Pedro is a patent attorney. I've interacted with him through many patent applications for several UCSD inventions that I manage. His expertise is on wireless technologies, software, AI, machine learning, neural networks, computer security, and medical devices. So welcome, Pedro, and please proceed.
Thank you, Victoria. And thank you everyone for joining us today on discussion about AI, machine learning, and really ways to protect it. And I'm going to give, generally what I want to do today is give you a little bit of motivation or context behind, as Victoria said, AI has been around for a while. I want to give you some context about the growth of AI, where it's been, where it's going. And then since I'm not familiar with everyone's background, I'm just going to spend a few minutes on some patent basics. And then after I do that, what I'm going to do is give you some, I'll call them tips or considerations for AI or machine learning related inventions that you can take away. And as you're as you're working with a patent attorney and you're trying to protect your innovation, that you keep these things in mind, because at the end of the day, they'll help you make the innovation stronger. My background, just I'll digress for a second, is I got a bachelor's in science in EE, and then a long time ago, actually. And then in the early 90s, I went to grad school. It would have been 91, got a degree a master's degree in EE. And my graduate work was in pattern recognition, machine learning. We were writing code for neural networks, doing face recognition. So as an engineer, I worked in this space. And you fast forward over the last 20 plus years as a patent attorney, I've been doing AI and machine learning inventions for a variety of companies and industries, and you name it, I've probably done it. Hundreds and hundreds of patent applications. And so I'm going to get into the specific tips from what I've seen, things you can do to strengthen the patent, and then some other considerations, and I'll leave some time for questions. So now AI, by NIST, has given it a formal definition. I tend to use the terms AI and machine learning interchangeably. So forgive me if I do, because I tend to use the term machine learning more often. As a patent attorney, we like the term machine learning because it connotes more a machine, and to the patent, it impresses the patent office a little bit more when you say the term machine, because it's a thing. Artificial intelligence seems a little bit more abstract to the patent office, so sometimes we avoid that language. But I'm going to use them interchangeably. Forgive me when I use them interchangeably, because really I'm talking about AI. So the patent office here, when they talk about AI, they have a bunch of different technologies they consider as part of AI, everything from machine vision, traditional machine learning, natural language processing, AI hardware, the chips, that people have specific chips to do neural networks, speech recognition stuff that's been around forever. So the whole host of technologies. And just to give you some context, and I do this because I often run into inventors that say, they're actually new to machine learning, and then they forget that this stuff's been around for a while. If you do a Google search for AI and machine learning, you get the Turing test in the 50s. We all remember, hopefully, the 2001: The Space Odyssey with HAL. And then more contemporary with my studies in the 80s and early 90s was, the autonomous car stuff that we're seeing today. People were working on it in the 80s. So it's been around for a while. There was kind of, they call it the winter. There was a kind of a winter in AI where we developed a lot of the techniques, but the processing power, quite frankly, wasn't there. I still remember doing face recognition in the 90s where we'd run something on a NET computer, which is one of Steve Jobs' old companies. And then we come in the next day to see the results because it took that long. So it hasn't been until the last decade or so that we've had faster processors where we're seeing literally explosive growth in AI. And that's why we're here today. And I put this little picture here because I'm from Rochester, New York originally. And here's this picture of the old IBM computer at University of Buffalo. And now, this is just to give you a little highlight of that. It literally is explosive growth. It started kind of in 2000 where we see AI type patent applications just basically zoom up. This is from the Office of the Economist at the Patent Office, where it went from almost nothing to about 15%, or actually probably at this point probably about 20% of all the patents at the Patent Office relate to AI. That's huge. And
are you able to share in PowerPoint mode, just for anyone that might have some issues, maybe with the size? It should just be at the bottom of the PowerPoint.
1 second. Hold on here.
Right down at the bottom, there's a icon that looks like a little PowerPoint.
Presentation. It's a screen, like a presentation mode.
Slideshow. There it is. Sorry about that. So, and you can see the next slide here. And this is just the Patent Office's categorization, all the different technologies that they consider AI, and where those technologies, the percentage of applications that are in those technologies. So with that said, you can see the growth, and you're seeing that UCSD. UCSD has been in the forefront of machine learning and AI since I was in grad school. So and UCSD has a big chunk of these applications that you see here. Now let's get into some patent basics. Generally, when we talk about patents, we're talking about utility patents. Utility patents are, they basically protect the way something is used, how it works, the structure. Think of the device or the process flow of software, the composition, and the threshold that to get something patented, it has to be new and non-obvious or non-trivial to what was done before. In other words, given the state of the art, is what you're doing, is it new, or are the differences between the state of the art and what you're doing, are they non-obvious? And then there's different sections. I'm not going to get into the specifics of all the different parts of a patent application, but the 3 parts that we should be aware of are the detailed description, and I usually give the analogy that the patent application is like a cookbook. It gives you step-by-step instructions of how to make your cake and how to bake it. And like any good cookbook, it has drawings, and these drawings show all the structure of, if it says sift, it shows you a picture on how to sift, because I may not know what sift means. So it gives you pictures that help the explanation. And then the last piece and the most important piece, and the piece that inventors and PIs often, or at least the less sophisticated inventors, forget to read the claims. The claims are literally the deed to your invention. They're the most important part, and it's the part that we as patent attorneys spent the most time strategizing on how to draft them. So, so take the time to read that and focus on that. And I have a key takeaway that I think that's important is when you're working with a patent attorney, you know, when you read the draft, and especially the claims, if something doesn't make sense, you know, raise your hand, you know, put a note in the document, send an email, because if it's not clear to you, you need to have a discussion with your patent attorney to figure out why isn't it clear? Is it a misunderstanding? Is it intentional? Because if it doesn't make sense to you, it may not make sense to the patent examiner at the patent office, or later on a judge, or even a licensee. You know, you want to license this technology to a med device company. If the claim doesn't make sense, you might have issues trying to get it licensed. So, you know, just take the time and get involved and have that discussion with the patent attorney and make sure you're on the same page. And here's, I'm not going to spend too much time on this, but here's a patent publication. It's not a patent quite yet. And just to show you how the drawings are showing all the key aspects, examples of the invention. It's showing a structure, a figure 1, a process flow. It has a detailed description. I only showed one paragraph, but this particular application has, it's like 13 columns of single space text of describing the structure, the data, how it's trained, the types of data, the structure of the network, how it operates using flowcharts. And at the very end, it has the claim. And again, this isn't the entire claim, it's just the very beginning. Now, the big issue with AI is patentability. And when I say patentability, I'm talking about, is the subject matter of the invention, is it an abstract thing, like a mathematical equation, an economic concept, something that's just not something that's just not a physical or a practical technology, or an application of technology. So it's something, and the reason I mention is if your innovation is simply a math equation, the patent office will say it's abstract. And you folks in the bio area have the same issues with certain areas in bio are more of a challenge when it comes to patentability as well, because they may be considered abstract. But so typically, as a patent attorney, we're well aware of this. We have to we carefully draft the application so that whatever your innovation you have, say it is an equation, we couch it in a way where it sounds, it has a technical application. It sounds practical. It's applied to a problem. It solves a technical problem. So, so perhaps you come up with a new equation to segment something, or segment an image, or detect whether a person's face is in an image. We wouldn't describe it as an equation. We may include the equation in the description as just a little bit of support, but we're going to talk about that equation in the context of solving the problem of detecting a face or detecting eyes and how it works. So now it doesn't become an abstract equation invention. It becomes a face recognition or image detection invention. So that it's all in the crafting of the application and how you communicate it to the patent office, but it's a pitfall that we try to avoid. The other area in machine learning is, and you know, people have been asking this question, and humans are the inventors. The HAL or Siri are not inventors. The machine learning itself can't be an inventor on a patent application. The U.S. Patent Office has ruled on that. To me, it makes sense. You know, machine learning is a tool, just like that's an old 1915 Bosch and Lomb microscope. I would, you know, in 1915 they weren't listing Bosch and Lomb as inventors or a microscope. So I'm not surprised the U.S. Patent Office has come out the same way on this. And interesting, in Europe and China and other countries around the world, are following suit with, or they all have similar policies on AI is patentable, so long as you couch it as solving a practical problem or a technical problem, and they also follow suit on the fact that the neural network can't be an inventor. Now, we were talking about technical effect or practical applications. You have to, if you have a machine learning or AI innovation, it really has to be, couched or explained in the context of an actual problem, technical problem, and a solution to pass it, to be considered patentable subject matter or be eligible. And I list some of them here, and it actually makes it, these are all, you're like, oh yeah, of course. These are all concrete, tangible things. Image processing, audio coding, they're all, you can go out and buy a codex, right? In drug detection, you can buy equipment that helps you with drug discovery. Facial recognition has been around forever as well. These are all tangible technical problems that machine learning is helping or is involved with or is part of. And you need to have this type of use case or this type of context for your machine learning innovation. Now, the other issue with machine learning is people ask, what can I protect in machine learning? And that really runs a gamut depending on where your innovations are. We get inventions that where the innovation is in the structure of the neural network itself or the machine learning, perhaps adding a new layer, a pooling layer of some sort, or how it's structured, the very technical things about the machine learning, how it's set up as well. And then you have other innovations that deal with how you train, how do you deal with scarce data? How do you, what types of data and how they're pre-processed and so forth to give you a better answer. And then some innovations actually deal with just the use of a certain type of machine learning to do a specific problem, like using training a machine learning model in a certain way, like a convolutional neural network, to detect, say, a tumor in CAT scan data. So it just depends on where your innovation is. And it's important to kind of think about where the nuggets of innovation are in your invention, so that your detailed description spends a lot more time describing those nuggets or the core innovations. I think it's really important that as an inventor, you do spend some time thinking about, where are the different points along my machine learning invention or innovation that there is something new that I want to protect. So, for example, if it's in the training, that you make sure you communicate that to the patent attorney and say, yeah, I'm doing something here new in the training. Not only there, I'm doing something new in the structure of the network, and not only that I'm also doing some things with privacy in the neural network. And so highlight those things so the patent attorney can make sure that not only the description but the claims capture that. Another thing as well is that with machine learning innovations, I think it's important to really, on some level, explain the entire process, whether it's training the model itself, and then once you do train, how you deploy that model, because you want to have that flexibility to be able to impress the examiner that, hey, we train the machine learning model. Once we train it, here's the trained model, and then we can deploy it so it's used and to perform some detection process or classification process or some other action. And you have to be able to tell that whole story at some level in the patent application. And I have another key takeaway here. I've heard many times from inventors that they think having a vague or broad patent application is better than a specific one. So I'm going to say that's wrong. You want details in your description. Think of it as you're putting all after the patent application is filed, we can't supplement it with your knowledge. So it's important that those four corners of the patent application capture all this knowledge that you have on the invention. Now, when people say broad, I hate to use the term vague, but when they say broad, the claims should be broader than the details of your application. In other words, if my innovation is, say, a certain way of doing of training the neural network, I may have a lot of description of how I do that with lots of alternatives, lots of examples, a lot of really specific details. But then the claim at the end will be maybe a sentence or two that says receiving some data and then detecting in that data a certain feature based on my machine learning model. So it could be very broad, but the description itself has all the specific details of how you do it, the alternatives, the definitions of terms. And I put at the bottom, be involved. Don't just kick the application to the patent attorney and not be involved. The more involved you are with the drafting, and the back and forth, the interaction with the patent attorney, the stronger the end product is. Over the years, you can see the inventors that are super involved in their application drafting process get a much better application when compared to inventors that kind of are less involved. And this is a unique, I think, a unique issue with machine learning innovations, in that you have a training phase often where you're getting all this data, you may be pre-processing it, you may not even have enough data, so you're generating synthetic data, and sometimes the innovation is there, and now you train the model, and now voila, you have this model, and then you may, that model may be what you sell to folks or that you license and you may put it as a service so people can get on the web and do their, access your service, and you charge them per use of the model, right? Now, so there's really two phases. One is the training phase, and two is the post-training or operational phase, where you have this trained machine learning model that works its magic. You really should have claims directed to both the training phase and the machine learning phase. Because in the example I gave, if I only have claims that cover the training, in that scenario, I'm done with the model, and say I build a model and I sell it to a med device company, and they're using the model, and they don't train, they'll never train the model. They rely on a second party to train let me say it differently. So say you've built this model, and now another company, let's just say Google tries to copy your invention, they train the model, and then now they sell the trained machine learning model to a medical device company. And your claims only cover training. So you can't, the medical device company, if you went to them and say, hey, you're copying my model, they'll come back to you and say, no, we don't train. Google trains the models, but they sell the models to us. So it'd be hard to stop. It'd be much harder to stop them from copying your machine learning model than if you had a set of claims that cover both the training phase and I call it the operational phase, the post-training phase. Sometimes that's, it can be a challenge if all the novelties in the training, but there's things that we do to help that. So be aware of that. Just try to have claims that make sense given the final end use or deployment strategy of the machine learning model. Also, think about it is asking your patent attorney to walk you through each and every word of a claim. In other words, get the claim up on a screen and then walk through that claim so you understand what the terms are. Especially machine learning, there's a lot of jargon. In other words, I could use a term like feature, and to me it can mean one thing, to the inventor it can mean something else, and to the patent examiner something else entirely. So it's important that you walk through the claim language, have a read through, discuss what things mean. If anything's unclear, either change the terminology or make sure it's defined in the specification or the detailed description. It makes a much stronger patent. Now, the last two things I want to touch on are trade secrets and copyright. So in the area of machine learning, people do protect some of their innovations with trade secrets. And first, let's say what a trade secret is. A trade secret is something that has economic value in trade, right? And it's a secret, and that you take steps to protect that secret. And here I show the Kentucky Fried Chicken recipe being, there's an actual photo of them moving the picture from one, or the recipe from one safe to another. In the machine learning area, there are companies out there that keep their back-end algorithm secret. I don't work on Wall Street, but I know for a fact that they use machine learning algorithms to tell them whether to buy or sell stocks. You don't see these big investment houses or hedge funds, not very often at least, getting patents on their machine learning algorithms. And it's because, they've decided they want to maintain it as a trade secret. They limit access, they protect it. The problem with trade secret protection is it does not protect someone else from doing the same thing independently. In other words, reverse engineering. So if go back to my stock trading machine learning algorithm, if another company could sit there and try to figure out how it's done and kind of reverse engineer it, and you can't stop them. Trade secret does not prevent someone from reverse engineering your innovation. Typically, the advice that we give clients is if it's truly a novel machine learning approach, then you should really protect it with a patent. If it's something that's just not new, it's not going to get a patent, or there's 30,000 ways of doing the task, then perhaps you consider trade secret protection. But usually the default is patent, and if you don't think you can get a patent at the end of, through the patent office, then you consider using trade secret protection. And I give the hypothetical again. This is my stock market example. That they're using just a plain machine learning model or some type of neural network to do this stock prediction. They're protecting the weights, the specific configuration, all that stuff. And with a trade secret, they make their employees sign all these documents. But perhaps what they're doing is not, unless their models aren't really all that new. It's just what, the specific recipe they're using. And then no discussion would be complete unless we, talked about copyrights. So just like software, your machine learning innovations can be protected using copyrights. The moment you create that software, for the machine learning algorithm, you get a copyright, whether you register it or not with the federal government. You get a copyright. Now the problem, it's a viable means of protecting your IP, but it's very limited. In other words, if you write for copyright protection, if I write code to produce that algorithm, someone else can write different code that does the same thing, and I can't stop them because there's both different creative works. And the best analogy is I can draw a picture of Mount Everest, and someone else can draw the same picture and copyright. I can look at Mount Everest and draw their own picture, and the copyright isn't going to help me because neither person copied from each other. They just looked at Mount Everest and created their own work. And the same thing with copyrights. So usually the advice we give is if you can get patent protection, that's what you do because it gives you broader protection. It covers the functionality. And where copyrights just protects literally just that work. And in the area of machine learning, you would get copyright protection for the actual code and arguably the specific weights and so forth. Now, are there any, I know I've covered a lot, but are there any questions on anything I said, anything general about protecting your innovations in the AI or machine learning space?
So if anyone does have a question, there is a Q&A function. If you can please submit there, that way Pedro can answer your questions. Looks like we do have one. What types of claims are a no-go?
What types of claims are no-go?
Yep.
So you can, so the, I'm specific at claims for machine learning intervention. So you can do all types of claims. You can do a claim that covers, we call them method claims, which would be, if you saw that flow chart earlier, that covers the steps like receiving data, generating a machine learning model using X, Y, and Z, outputting a result. You can have a method that covers the use. So someone actually covers the use. You can have we call them apparatus or system claims that cover the thing. In other words, the physical computer or processor or watch executing your code or your algorithm. That'd be an apparatus claim. There's also these things called Beauregard or computer real medium claims that covers the code when it's stored on a hard drive. There's any variety of claims. So there's machine learning and AI innovations are just like other innovations. Whatever, you can get as creative as we want with the claiming strategy.
Pedro, I have a question. So are the patents for machine learning treated differently in like the medical area versus just regular engineering?
Yeah, so if you ask the patent office, they'd probably say no, but I think yes, they are. So you know, there'll be inventions that are, so say you have a medical device like some type of blood glucose monitor, right? And you file a patent application to this blood glucose monitor, and it'll go into the blood glucose monitoring art unit. And if really the invention is the blood glucose monitor is doing it using is detecting whether you're going over or under based on a convolutional neural network, now the innovation is being examined by someone who's used to looking at monitors, and now they're examining the AI aspect of it. So why does that matter? Because that the AI or machine learning would probably, well, it's going to seem fresher or newer to that blood glucose examiner when compared to an examiner that just looks at AI stuff, if that makes sense. You know, if you're just a judge that looks at traffic tickets all day, you're going to be, it's going to be hard to impress you. But if you're a judge that doesn't see traffic tickets all the time, they'll pay attention. So going back to my previous example, if you're always looking at blood glucose devices, and now you get one that talks about AI, it's going to impress the examiner more. I think it gets handled a lot better at the patent office. You're more, in my opinion, you're more likely to get a patent. So that goes back to my first point, where it's important to couch your invention based on the end use or the deployment, the practical application, because that way it gets categorized in that practical application. It helps it get allowed. It's not going to be considered abstract, like just some abstract AI innovation. It's going to be a drug discovery device. It's going to be a blood glucose monitor. It's going to be a codex, and that's better for you, the inventor, because you're more likely to get a better result. That's a good question.
like we have another one. What are the typical rejections on claims you tend to get from patent examiners?
So for AI, you're definitely going to get you may get what's called a 101, which is an Alice rejection, which relates to is your invention abstract, like an equation, economic concept, some mental manipulation invention, or is it something a human can do in their mind, right? Or is it something tangible, practical, or technical application? And that's the 101, and that's the most common, and that's important to overcome that. If you write the patent application as an abstract thing without explaining the end use or the end uses, you're going to have more problems with this 101. And even if it gets to the patent office, it may not survive a judge later on, or a jury, or scrutiny. So what you have to do is explain the AI innovation in the context of a technical problem. For example, a blood glucose monitor, or a codex, or something very specific. So now it's less like, so now when the examiner says this is abstract, it's just you do math optimizations. It's just a math problem. You can say, no, this is a physical device that solves the problem of detecting blood glucose in this monitor. And then you win that argument. The other two you're going to get, it's called anticipation and obviousness. And they go back to where I started in the beginning, where I said your invention has to be new and non-obvious. 102 means the examiner thinks your invention is not new. In other words, it's just like what someone else did. And we tend to, that all depends on the claim language. So we tend to work with the examiners and with the inventors to help explain why you're different than the state of the art, or what the patent office finds. Because once you file it, they do a search and they'll find another patent or publication, and you have to explain the differences. 102 is typically the anticipations, easy to overcome, because you're explaining to the examiner, hey, these two are different because, and you list all the specific differences. 103 or obviousness, that's a little bit more subjective, because you're telling the examiner's saying your invention is different than what was done before, and they'll give you one or two documents to show what was done before. But the examiner is saying, I'm not impressed that those differences are sufficient to get a patent. In other words, that the differences between your invention and the claims, and that the claims define the invention, and this prior art are trivial. And that's a little bit tougher to overcome. And for that, we have to argue what those differences are, explain and argue to the examiner why the differences aren't trivial. And then we often actually, we'll work with the inventors often to get their input on this. And then usually the most important tool is we'll have what's called an examiner interview, where we get the examiner on a phone, and it's a formal interview. And what we do is we kind of tell the story of the patent, of the invention, where we say, hey, the inventor was solving this problem. There was a problem in the, I apologize, I keep going to blood glucose monitor, but the inventor was solving this problem that in the blood glucose area. And you kind of tell them that story of here's the problem, and then here's why the invention is cool, to use lack of a better term. This is what the inventor did. See these features in the claim, they're not in the prior art. And it would have been a leap to do this. So you're kind of, I hate to say pitching, but you're actually explaining that you're pitching the invention to the inventor, or to the examiner, explaining why it's so cool, and persuading them that they're non-trivial. Now, there's other arguments we make that are very specific on why they can't combine them. There's other technical arguments we make to overcome 103. But at the end of the day, it's persuading the examiner that, yes, it's different, and here are the reasons and why they're not trivial, why the differences are not trivial. And usually, for the most part, at the end of the day, we typically, we do persuade the examiner.
Thank you so much, Pedro. And then we do have another toolkit series coming up on April 27th. Yep, there we go. So this one is going to be on the basics of financing. We're in partnership with Tech Coast Angels on this. You can find out more about all of our events on our website. Victoria, I don't know if there's anything you want to recap about the innovation commercialization process or just close it out for us. But this has been great.
Yeah, thank you very much, Pedro, and thank you to Mintz for sponsoring this event. And I thank all the participants as well, and would welcome you to the next one. Thanks very much.
Thank you. And I also would like to add that if you have a UCSD address, you can log on to our Startup Tree platform and make an appointment to meet with one of the Mintz attorneys who are on that platform. So take advantage of that, and but only if you have a UCSD address.
Well, thank you, everyone.
Thanks, Pedro.